Afternoon, everyone. So today, this is our second last lecture for this fast track course. And today, as I told you, we are going to discuss with administration of UT. So the idea is UT and the tribunal. So let's start first with a concept regarding UT, how union territories as a body came into existence. So this is basically for your prelims. I have created this table. Reason because questions like this has been asked, that what are the union territory, what is the capital, and what is the year of creation. So if you can figure out, it is Andaman and Nicobar, capital is Port Blair, year of creation comes out to be 1956. Then becomes Lakshadweep, Kavarati is the capital, again 1956. This means NCT of Delhi. हाँ सर भैया अच्छा आपको दिए okay so so you see, even if before I go to this table, let's figure this out. So you remember when we were discussing, this was probably our second lecture, when we were discussing about what is union and what is territory in India. I told you that there were part A, B, C and D which were being created, है ना? Which after State Reorganization Act, they were again being recreated into states and UTs. So now those states and territories who were in part C and part D, they were being replaced by union territory in part 2 of the first schedule, right? So basically the idea came up from part C and D, and later on they were being named as UTs. So this is the chrono in which the union territories were being created, the most recent being Jammu and Kashmir and Ladakh. After 2019, state reorganization happened. So now what kind of question can come up? Of course, one question can come up keeping into mind the chronology. So they can ask you what is the chrono. They can even ask you that simultaneous Andaman Nicobar, Lakshadweep and NCT of the Delhi were being given the union territory status. Again, there is Nadar and Nagar Haveli and Daman and Diu, and see what I have written. So now this is another very important idea regarding the Constitutional Amendment Act 2019. Generally 2019 ke amendment ko we link with reorganization of 2 UTs, but that is not totally correct. There is another idea that UTs of Dadar and Nagar Haveli and Daman and Diu were merged by Dadar and Nagar Haveli, Daman and Diu merger of UT Act 2019. So abhi initially it were 2 UTs, right? Daman and Diu and Dadar and Nagar Haveli. Now they are being fused together. ये जो fusion हुआ है, this also happened as per this Amendment Act 2019. ठीक है? तो Amendment Act 2019 में this change happened and this change happened. So there were 2 changes which happened as far as reorganization of the state is concerned. And also see, simultaneously Puducherry received the UT status, and simultaneously same year Chandigarh also received the UT status. Kindly figure out like-minded ideas क्या है कि एक साथ कौन-कौन से UTs को they got the status simultaneously, right? Next, as I already told you, part C and D of the first schedule, they were being replaced by union territories in part 2. And this was through the 7th Amendment Act 1956. 7th Constitutional Amendment Act kab hua? After there was this huge amount of controversy regarding state reorganization, I told you, and therein the state reorganization also happened, right? Delhi, Himachal Pradesh, Manipur, Tripura, Andaman Nicobar, Lakshadweep, Minicoy, Amandivi Island were the 6 UTs at that point. So once the state reorganization happened, after that UTs were also created. जैसे states create हुए वैसे UTs create हो गई. How many UTs at that point were created? 6 UTs were created. Of course, that has undergone changes, and later through successive amendment, now there are total 8 UTs. ठीक है? So earlier there were 6 UTs, now they are 8 UTs. Okay, now we will be referring to what are the constitutional provisions regarding administration of UT. Sabse pehle to we will figure out what is the part. So this is part 8 of our constitution. So first, this is part 8 of our constitution. What are the article? Article 239 to article 241. This deals with UT, right? So now एक एक करके सारे articles देखेंगे. What is the chrono? Today what we are going to discuss, online student also. So what we are going to discuss? We are going to discuss Delhi, we are going to discuss Puducherry, we are going to discuss one of the most important idea, what are the reasons for the tussle between Delhi and the center government, right? And then we are proceeding to tribunal part. So basically idea comes up from Article 239. Up 239 mein there are sub clauses. The first sub clause is 239 clause 1. This provides that every UT shall be administered by President as he thinks fit through administrators to be appointed by him with such designation as he may specify. So clearly it is being said that a UT shall be administered by the President through people or through administrator he feels fit for that job. Also, what is the nomenclature? This will differ from UT to UT, right? So in an exam, a question can come up that it is administered by Parliament. No, this is wrong. It is administered by central government. No, this is also wrong. UT are being administered by the President. Parliament may by law provides otherwise, right? Now, second is Article 239 Clause 2. What does that say? That a governor of a state may also be appointed by President as administrator of the adjoining UT, where a governor is so appointed as administrator from UT, he shall exercise his function as administrators independently of his council of minister. इस पे बनता है question. So what the point is कि अगर एक UT का एडमिनिस्ट्रेटर नहीं है तो of course president is there, he is fit to appoint him, or then parliament, otherwise parliament can create definitely a law enabling president to create this idea. लेकिन administer होगी president से ही and he would be appointing the administrator, right? Suppose there is a UT and there is an adjoining state and president feels that the governor of the state should take forth the responsibility of being an administrator of an adjoining UT. So in this regard, the job profile of governor will change. In a state, governor will act in aid and advice with CM. And when he becomes an administrator of the UT, he would be administering independently of his council of minister. Probable reason is because governor is considered to be the agent of the center. So in this regard, and UT we all know is directly administered by the center. Probably this is the reason why he would be administering independently, seeking the advice of central government whenever necessary. The administrator appointed under clause 1. Clause 1 मतलब जो president administrator appoint कर रहे हैं has such power as conferred on him by the president. But he does not have the power to do anything in the UT which the president can do. This means, of course, the overarching power is that of the president only. He is just going to be the agent of the president in that particular territory. So now we have discussed about Article 231 and Article 232. Now coming Puducherry, 2391 and 2392, and now it is coming Puducherry. So again, if we refer to what is the range is 239 to 241. ये हमने 239 का clause A देखा, this is 239 clause 2, and now this is 239A, right? उसके बाद 240 देखेंगे, फिर 241 देखेंगे. So 239, 238, 240, 241. These are the 4 clauses concerning UT. So we are now discussing 239A. 239A talks about creation of a legislature or council of ministers for Pondicherry, or later on it is known as Puducherry. So now there is Article 239A, which provides that Parliament may by law create for Union Pondicherry a legislature or a council of minister or both. The law so created may be an elected or partly nominated and partly elected. Such law shall determine the constitution, powers, function of the legislature or council of ministers so created. Any such law shall not be deemed to be an amendment by the Constitution for the purpose of Article 368. This point becomes very important for your prelims. So what is an idea? That Article 239A is there. 239A talks about creation of Union Territory Puducherry, and for Puducherry a legislature or a council of minister or both. When I say legislature, iska matlab legislative assembly, or it could be council of minister, that is there would be an administrator which would be assisted by council of minister. So now the law so created, it may be elected, it may be partly elected, it may be totally elected, it could be any idea. And if any such law is being made by the parliament, it should not be considered to be an amendment. This is very important. Okay. Second is Article 239A. This particular article which talks ki Union Pondicherry mein, in UT Pondicherry we can create a legislature. This was inserted by the 14th Constitutional Amendment Act 1962. So this was 14th Amendment Act 1962. Now another article is Article 239B. So for your memory, you should remember Article 239A, 239B for Puducherry, 239AA and 239BB for Delhi. ठीक है, एक और add हो जाएगा, that will become for Delhi, and if it's only A and B, it would be for Puducherry. Now 239B says what is the power of administrator, especially to promulgate ordinances. So this article confers on the administrator of the UT power to promulgate ordinances. Ordinances, of course, are one mechanism wherein executive can take forward the task, and it can take forward whenever some important matter comes up. So यहाँ पर the head would be administrator. An administrator have the power to issue ordinances. The legislature, or what is the condition? When the legislature, that is the state, that UT Legislative Assembly, the legislature of UT is not in session. Of course, ordinances तभी release होते हैं when the houses are not in session. अब वहाँ पे दो house तो होंगे नहीं. There is only going to be one house. So when Legislative Assembly, that is the legislature, is not in session, then of course ordinance could be issued by administrator, and when the administrator is satisfied that circumstances exist that it becomes necessary for him to take immediate action. यहाँ और नहीं है, and है. This means both the two conditions have to come up. No doubt when it is not in session तो primary condition होगी. But every time when it is not in session, no need for an administrator to issue an ordinance. Usme bhi, if administrator feels that conditions have come up now, there is no way out other than passing an ordinance, he would be passing an ordinance. However, no such ordinance shall be promulgated by administrator without prior instruction from the president. So again, the idea is same, that since president has appointed this particular person as administrator, what all this administrator is doing, he would be seeking advice from the president. Okay? So clear? So there are two articles, 239A, which is talking about creation of a legislature as far as Puducherry is concerned. And then there is 239B, which says that ordinance making power can also be given to administrator when these two conditions are there, and at the same time, every time he has to seek the advice of president. Okay? So this is regarding Puducherry. Now let's move to NCT Delhi. अभी controversy part पे नहीं आए, अभी in general समझते हैं. So as I told you, याद करने के लिए क्या है, Article 9 239A 239B is there for Puducherry. इसी में AA और AB लग गया है. So this is coming to be that of NCT. Now 239AA says administration of National Capital Territory Delhi. This was first of all inserted by 69th Constitutional Amendment Act 1991. So this question of course comes up. What was the amendment? We will say 69th Constitutional Amendment Act. Now as per this particular article, Union Territory of Delhi now would be called as NCT Delhi, National Capital Territory Delhi, and administrator thereof of course would be appointed again under Article 239, and he shall be designated as Lieutenant Governor. यहाँ पर ये इसलिए लिखा है because Article 239 clearly says that it is the president who has the power to appoint any person as an administrator of any of the UT. So as per Article 239 there would be an administrator, लेकिन पुडुचेरी की तरह the name won't be that of administrator. Here he would be known as lieutenant governor. There is a difference. It is not anywhere mentioned what is the difference. Thus the difference is by NCT को status भी different दे दिया ना. अभी afterwards, after we are done with the entire NCT in Puducherry, I will tell you what is the difference as far as Puducherry and NCT Delhi is concerned. So NCT को नाम दिल्ली को NCT ही इसलिए बोला because it is a capital territory. This is the reason its administrator won't be considered with the same name as you are considering with any other UT. This is the reason this administrator is called lieutenant governor, just to provide it a feel good or different zone में ले जाओ, so that Delhi consider itself to be quite different from other UTs. Okay. Second is Article 239 AB. ठीक है. Now this talks about failure of constitutional machinery in NCT. आप trend देखो, trend is same. 239A there in Puducherry talks that there would be an administrator who would be appointed by the president. 239B there says that this administrator would be given a power to issue ordinances when such condition comes up, and every time he has to refer to president. See, the order is somehow the same. वहां पर भी president is given some extraordinary power in order to, whenever ordinances are issued, president would be consulted. Here also the idea is how and when the center can intervene, right? यहाँ पर idea बोल दिया है ordinance का नहीं, यहाँ idea है failure of constitutional machinery. So Article 239AB contain provisions similar to those contained in Article 356. Agar prelims में this statement is coming, you are marking it correct. So as per in state there is failure of constitutional machinery. Similarly, there is an idea in NCT also, in respect of proclamation declaring the breakdown of constitutional machinery. Article 239AB provides that if president, on the report from lieutenant governor or otherwise, बिल्कुल यही idea है in Article 356, that if a president on recommendation or report of governor or otherwise feels that there is a constitutional breakdown or state has not actually obeyed the direction of the center, in these two cases president rule can be imposed, right? So if this condition is there and president now gets satisfied that a situation has arisen in which administration of NCT cannot be carried out as per the provision of Article 239AA or any law pursuing to that article, or that for the proper administration of NCT it is necessary to do so, then or president may by order suspend the operation. These two are the conditions. So what are the conditions? One, it has been said that administration cannot happen as per Article 239AA. Two, it is said that it is very important and very necessary for administration of NCT that immediately president rule must be imposed. So in this case, what will happen? President may by order suspend the operation of any provision of Article 239AA or all provision of any law made in pursuance to that article for such period and subject as he may specify. So सबसे पहले president what he will do, he will try to suspend the operation of Article 239AA. Why he would try to suspend this? Because this particular article is saying that there would be a lieutenant governor. Of course, then there would be an assembly. The assembly and lieutenant governor together will look after the affairs of Delhi. So immediately ये article को they would be avoiding. Second, make such incidental and consequential provisions as may appear to him necessary for administering a NCT in accordance with the provision of Article 239. And accordingly, then president can take whatever action he wish to take. So this point becomes important. He immediately suspend the operation of any provision of Article 239A. Now, what I said, that administration of UT are being governed from Article 239, 239, 240, 241. So we have figured out what is Article 239, then we figured what is for Delhi and what is for Puducherry. 239AA, 239AB, 239A, 239B. Itna हमने पढ़ लिया. Now we are to 240. So 240 says power of the president to make regulation for certain UTs. So president may make regulation for peace, progress and good governance of UT of Andaman Nicobar, Lakshadweep, Dadar and Nagar Haveli and Daman Diu. Abhi to all these categories are seen together, so you would be writing also together. I told you, no, this is subsequent to Constitutional Amendment Act 2019. Puducherry and such other UT as may be specified by law made by the Parliament. अभी prelims में क्या question बन सकता है? 240 के अंदर whether NCT Delhi is coming or not. So you will figure out that no, NCT Delhi explicitly is not mentioned as far as Article 240 is concerned. Rest all the UTs are being mentioned, right? Abhi to new UTs like Jammu and Kashmir and Ladakh are also included. They would also be included. But of course, Delhi is not being mentioned. As we have, or इसी तो लिखा है such other UT as may be specified by law. तो लॉ के बाद जो जो यूटीज बनती जाएंगी, यू विल कीप एडिंग. बट सिंस एनसीटी इज बीन गिवन अ स्पेशल स्टेटस, इट इज नॉट बीन मेंशन्ड. As we have already learned that the law enables parliament to create legislatures, but president can only exercise his power when the legislatures have been suspended. So this particular power of president to make regulation will only be possible when legislatures are suspended. When legislatures are working, then of course this power president can't have a overlapping powers thodi hongi, that lieutenant governor along with assembly is also taking action and then president is also making action. No. So only and only when the legislatures are not in a session or they are being suspended. President has no power to make regulation for peace, progress and good governance with effect from the date appointed for the meeting of the legislation. So moment the legislature now start meeting, now president will have no power to make regulation. ठीक है. तो इस वाले हैंडआउट से एक तो क्वेश्चन दिल्ली को लेके आएगा, एनसीटी दिल्ली, एंड सेकंड थिंग वुड बी दैट व्हाट वुड बी दोस कंडीशंस. सो यू वुड से इट वुड बी ओनली कंडीशन व्हेन लेजिस्लेचर्स आर नॉट एट वर्किंग. Moment they again start working, now president 240 is not applicable then. Next provision is Article 241. 241 basically is dealing with high courts for UTs. ठीक है. So the parliament by law can make a court in the territory, the high court for any of the constitutional purposes. So किसी भी neighboring high court का jurisdiction it can increase and it can include UT within that jurisdiction. It also states that any high court that have a jurisdiction over any UT before the creation of constitution will continue to do so. Suppose there is a neighboring high court which has been taking forward an idea of Goa administration. So this was before the constitution and before Goa became formally the UT. So in that case, I'm just saying, in that case, you can continue with that idea as well, subject to the constitution or legislature's requirement. Every UT is administered by president, acting through an administrator appointed by him. The president can specify designation of an administrator. Either it could be lieutenant governor or it could be chief commissioners or it could be administrator. That will depend upon a number of reasons. It will depend upon what was a historical name. Agar historical name was continuing, so we will continue with that name. Or like in Delhi, whether it is being given a special status or not. President can also appoint the governor of the state as administrator. This is the summary, overall summary. Under Government of India Allocation of Business Rules 1961, Ministry of Home Affairs is the nodal agency for all matters regarding UT. This is also one question which comes up. कौन सी ministry के अंदर UTs and their administration are taken up? You will say Ministry of Home Affairs. relating to legislation, finance, budget, service, appointment of lieutenant governors, administrators, etc. So this is Article 241. So अभी तक हमने देख लिया Article 239, Article 240, Article 241. Now there are few more ideas that what is the expanse of legislative power of the center over UT, what is the expanse or the domain or expansion of judicial power as far as UTs are concerned. Legislative power में देखो, Parliament can make law on any subject of the three list, that is state list also for the UTs. So UTs may it can, so Parliament, that is Central Parliament, can make law on the subject of the three list, of course including state list for the UTs as well. So UT के ऊपर Parliament can be making law. This power of Parliament even extend to Puducherry and Delhi, which have their own local legislatures. So despite you have your own local legislatures, of course, since तीन ही list हैं, one is union, one is state, one is concurrent, and then there is residuary. So all the subjects which are there in the state list, उन subjects के regarding in UT, Parliament will be making laws. समझ में आया? So now, for instance, education state subject है कि concurrent है? कल हम लोगों ने पढ़ा था. Health क्या है? State, ठीक है? So suppose like health, education is a concurrent, इसीलिए NEP वगैरह आ गया. अगर हम core एक state subject देखें, जैसे कि health. So yesterday we were discussing, no, जब हम PRIs कर रहे थे, delineation of functions पे confusion हो जा रहा है. So as far as the health ideas in UTs are concerned, UT is not going to make laws. Who is going to make law? Union Parliament is going to make law. यानी वो subject जो state list में है, for those subjects in UT, center will be making laws. So this is also a very nice question for your prelims. The Legislative Assembly of Puducherry can make laws on any subject of the state and concurrent list. ऐसा नहीं है. So this power extend to Puducherry as well. However, Puducherry and Delhi again have been given few more extra powers. So Legislative Assembly of Puducherry also have the power to make laws on state list as well as concurrent list, but again the same thing. If there is an overlapping, then of course central law shall prevail. Similarly, Legislative Assembly of the Delhi can make law on any of the subject of the state list except, यहाँ पर और ज़्यादा difference आ गया, public order, police and land and concurrent list. So now these three are very important idea because NCT is not only capital, it is also one of the most important area in terms of diplomacy also. This is the reason security is a very important idea, land is a very important idea, public order is a very important idea. This is the reason those state list के सभी subjects are provided to the Legislative Assembly of NCT except these three subjects. And because these three subjects are not being provided, this has become a ground for tussle between center and the NCT Delhi. ठीक है? अभी इस वाले आइडिया को हम डिटेल में डिस्कस करेंगे. So these are the ideas. As far as judiciary is concerned, Parliament can establish a high court for a UT. हमने पढ़ा है. Article 240 is there, right? So Parliament can establish a high court for UT or put it under the jurisdiction of the high court of an adjacent state. Delhi, however, is the only UT which has its own high court. So this question can also comes up on prelims. So since 1966, Delhi has come up as a UT having its own high court. Now let's quickly look what else we have discussed. We have now discussed Article 239, 1 and 2. Then we discussed 239A, 239B regarding Puducherry. Then we discussed Article 239AA and 239AB regarding Delhi. Then we went to 240 and then we went to 241 for high courts. Okay? Then we have discussed what are few more extra legislative powers, and then we have discussed what is the issue regarding the judicial power. Now come up a very important question. What is the difference between the status or the nature of administration of Puducherry and Delhi? So what is the difference? Point number 1. LG of Delhi enjoys greater power than LG of Puducherry. The reason are very evident because हमने अभी पढ़ा, as far as state subjects are concerned, Puducherry and Delhi Legislative Assembly can take their own actions. But as far as Delhi Legislative Assembly is concerned, it is the action or the scope is even reduced. because there are three important subjects of the state list which are being taken and given to the center. This means center ka agent hai LG. This means LG of the Delhi has a greater power as compared to LG of Puducherry. ठीक है. Next, LG of Delhi has executive functions that allow him to exercise his powers in the matter connected to public order, police and land in consultation with Chief Minister if it is so provided under any order under Article 239 of the Constitution. So next idea is this, that LG of the Delhi, who is going to be a center agent, is allowed to exercise his power as far as matters concerning these threes are concerned. And if there is any order, then LG can of course have a consultation with Chief Minister, subject to any order. If there are no such order, then as far as these three subject is concerned, center in guise of LG or proxy presence of LG can directly interfere in Delhi as far as these three subject is concerned. और यही एकमात्र reason है issue between center and NCT Delhi. LG of Delhi is also guided by Government of National Capital Territory of Delhi Amendment Act 2021 and Transactions of Business of Government NCT Rules 1993. While if you look into LG of Puducherry, it is mostly guided by Government of UT Act 1963. Last is center has more prominent role in NCT Delhi rather than Puducherry. And if someone asks the reason, that definitely you can say probably the reason is because of the importance of NCT Delhi not only being the center but also being the center of power and a great diplomatic presence, right? अब आता है one of the most important idea, NCT of Delhi, special provisions which are given to Delhi, which was after the 69th Constitutional Amendment Act 1991. So now, as per this particular Constitutional Amendment Act, it redesignated the UT of Delhi as NCT Delhi, National Capital Territory Delhi. Yani before 69th Constitutional Amendment Act, it was just known as UT of Delhi. After that, it is known as NCT Delhi. तो एक तो ये change कर दिया. Second, designated the administrator of Delhi as Lieutenant Governor of Delhi. So second important change was this. From now onwards, administrator will be known as Lieutenant Governor of Delhi. Third, when this constitutional amendment came up, Legislative Assembly was being created for Delhi. And this Legislative Assembly, of course, will have a Council of Minister. And if there is a Council of Minister, of course, there is going to be a CM also. So this kind of idea came up that there would be Legislative Assembly, which would be the lawmaking body. And then there would be an executive authority. This would be CM as well as Council of Minister. And since we are following a parliamentary model, this is the reason it was very obvious that the CM and Council of Minister will also be part of Legislative Assembly. ठीक है? The Chief Minister is appointed by President and not by Lieutenant Governor. This is a very important idea. So जिस तरह से बाकी typical Chief Ministers are there in different states who have been appointed by Governor, no, in NCT Delhi the status is different. क्योंकि आप उसको चाहे जिस भी नाम से बोल दो, after all it is UT of Delhi only. And a union territory, of course, is always centrally administered, directly centrally administered. So an LG is also appointed by President and a CM is also appointed by President. In case of failure of constitutional machinery, the President can impose his rules in the territory like a typical, President rule in any of the state. And what would be the ground that I already told you? There would be two grounds. One, the particular administration is not following the constitution, and two, it is itself not capable to carry forward administration, and in such a situation, President can impose a President rule. Now, what is the governance model of Delhi NCT? और questions आएंगे तो पुडुचेरी से ज़्यादा दिल्ली पे आएंगे. Reason because it has been into controversy, right? So one is classification as a UT. Under State Reorganization Act 1956, Delhi was classified as UT, governed under Article 239. Initially story कब से शुरू हुई? State Reorganization Act 1956. Delhi was being declared as a UT. कहा गया it will be governed by Article 239. After that happened the amendment wherein it became Delhi se NCT Delhi, and therein its nomenclature also changed. It states that Delhi UTs are directly governed by President or an administrator appointed by the President. So this was an initial conditioning. Then there was special status attached to Delhi. Following the recommendation of S. Balakrishnan Committee. Right? तो पहले दिल्ली सिर्फ यूटी थी, उसके बाद आई S. Balakrishnan Committee. S. Balakrishnan Committee was looking into the prospects of giving special status to Delhi. Of course, keeping into mind the centrality or the focus of center or power was there in Delhi, इसलिए S. Balakrishnan की committee बनती है. This particular committee recommended that special status should be given to Delhi. Consequently, the 69th Constitutional Amendment Act 1991 came up. Once this particular Amendment Act came up, special status was being given to Delhi and it was redesignated as National Capital Territory of Delhi. Okay? So initially it was just a UT of Delhi, then came the S. Balakrishnan Committee, then after that recommendation happened 69th Constitutional Amendment Act, and then NCT Delhi got established. Now when this 69th Constitutional Amendment Act came up, two articles were added, Article 239AA and 239AB. 239AB made Delhi a UT with a legislature and a council of ministers. ये हम already discuss कर गए. The LG is designated as an administrator of Delhi, operating with aid and advice to Council of Minister. So this was an article which was being inserted after 69th Constitutional Amendment Act 1991. Now what was the power which was being given to Delhi legislature? Delhi Legislative Assembly has the power to legislate over the subject on state and concurrent list. Puducherry ki Legislative Assembly is also given the same functions. But as far as Legislative Assembly of Delhi is concerned, it cannot make laws on police, public order and land. This makes LG of Delhi more powerful than an administrator in Puducherry. क्योंकि Puducherry में on all the state subjects, the Legislative Assembly of Puducherry can make laws. Right? The Delhi government has executive power over the same subjects. But as far as these are concerned, this has been the purview of center. Also, Parliament can legislate over all the matters in state and concurrent list related to Delhi. तो देखो overlapping powers तो बिल्कुल है, no doubt. And of course, if वैसे तो center will not make, because unnecessary, why would a center has a number of other things to do? Why would unnecessary center start making laws on subjects on state list? So till center does not intend to make laws on subjects of state list, UT will continue making laws. But if center feels that I should make law, then center law of course will prevail. Okay? So the status is that Delhi Legislative Assembly can legislate over subjects in state and concurrent list except these three subjects. And Parliament can also legislate over all matters in state and concurrent list related to Delhi. In case there is any kind of overlap, of course, center laws will prevail. And as far as police, public order and land is concerned, only center can make law. Okay? Now there is Government of National Capital Territory Delhi Act 1991. 69th Constitutional Amendment Act जो आया, it was known as Government of National Capital Territory of Delhi Act 1991. This lays down the framework for the functioning of Delhi Assembly and Delhi government. So there are two entities now. There is a Legislative Assembly, जिसको हम कहेंगे Delhi Assembly. Or Delhi Assembly, because it's a parliamentary model, this is a legislature, you require an executive, तो Delhi government भी होगी, with Chief Minister and Council of Minister. तो उनका फ्रेमवर्क इज बीन प्रोवाइडेड एज फार एज दिस पर्टिकुलर एक्ट इज कंसर्न. प्रीलिम्स में इफ दिस एक्ट कम्स अप, दिस मीन्स गवर्नमेंट ऑफ नेशनल कैपिटल टेरिटरी ऑफ दिल्ली एक्ट. वैसे तो यूपीएससी विल नॉट ब्लफ, उनको लिखना होगा तो वो पूरा लिखेंगे, ये विल नेवर गो फॉर शॉर्ट फॉर्म्स. It outlines the powers of the assembly, the discretionary power of the LG, and chief minister's duty to provide information to LG. ठीक है? So this particular act is dealing with each and every aspect. What is the area on which CM can make laws? What are the areas on which LG have special powers? What is going to be the duty of CM as far as LG is concerned? Now, what is the present status of Delhi as UT? The 69th Amendment gave National Capital Territory of Delhi a special status. Special status kyun? Because it will have, not only it is known by a different name, National Capital Territory of Delhi, but also it will have its legislative assembly, it will have its elected government. There were insertion of 2 articles I told you. This is 239AA, 239AB. Legislative Assembly have the power to enumerate anything in the state list or in the concurrent list as insofar as any such matter is applicable to UTs. Provided that in case of a difference of the opinion between the Lieutenant Governor and his minister on any matter, the Lieutenant Governor shall refer it to the President for the decision and act according to the decision which President is giving. This is the speciality in Delhi. कि भाई स्टेट और कॉन्करेंट लिस्ट में स्टेट बारिंग पुलिस पब्लिक ऑर्डर एंड लैंड, इसके बारिंग दिल्ली असेंबली और गवर्नमेंट कैन मेक लॉ एंड एक्ट ऑल्सो. बट सपोज एलजी फील्स दैट देयर इज अ लैक ऑफ डिफरेंस ऑफ ओपिनियन बिटवीन एलजी एंड सीएम, सो एलजी हैव द पावर टू रेफर दैट मैटर डायरेक्टली टू द प्रेसिडेंट. And then decision would be taken by president. Probably this is also one of the reason for the issues. Public order, police, land and NCT falls within the domain of union government, right? Now there is article 239AA. फिर से जरा जल्दी से देखते हैं. Inserted by 69th Amendment. Provide NCT with an administrator and who is called LG and a legislative assembly. Assembly will make laws in state list or concurrent list except police, public order, land. In case of difference of opinion by LG and minister, LG shall refer it to the president. Now this is the chronology to showcase what was happening between center and Delhi, right? So I am so online student going to be, I don't know if they are able to see this or not, but I can't elaborate or I can't zoom it because then the entire formatting will get disturbed. So I am speaking out, kindly hear it properly. So in 1956 what happened? Story कब से शुरू हुई है? 56 से. State Reorganization Act is passed. Delhi is being given the status of a UT. Then what happened? 1991-92. Now S. Balakrishnan Committee comes up. S. Balakrishnan Committee says that Delhi should be given a special status. Subsequently, the 69th Constitutional Amendment Act 1991 came up. As per this particular Amendment Act, Article 239AA and Article 239AB is being inserted. Article 239AA and apart from that, Government of National Capital Territory of Delhi Act also comes up, right? After this, there was the 70th Constitutional Amendment. This was also passed, which provides for certain laws of the Parliament to not to be deemed as an amendment to the Constitution. Remember I told you that it was being said that if Parliament somehow in its capacity make certain laws for the UT, it won't be deemed as an amendment. So this particular idea came up with 70th Constitutional Amendment Act. ठीक है? Then happened 2015. Basically जो अभी हम controversy देख रहे हैं, this is all actually तो idea more is for mains. But then I can't skip, just because it's a prelim session, I can't skip the entire thing. क्योंकि फिर कोई यूटिलिटी नहीं रह जाएगी डिस्कसिंग दिल्ली एंड सेंटर. So the issue actually started from 2015. Ministry of Home Affairs, I told you, this is the nodal ministry for administration or making any rules and all regarding UTs. So now Ministry of Home Affairs issue करता है एक notification. This notification takes away the control over services from Delhi legislature. Services as in services which administrators are providing in Delhi. Services was regarding the government officers' सर्विस कंडीशन एंड देयर ट्रांसफर कंडीशन. तो ये कहा गया कि जो दिल्ली में है सर्विसेज और द एडमिनिस्ट्रेटर्स मीन सिविल सर्वेंट्स एंड ऑल, उनका सर्विसेज एंड देयर ऑल देयर आइडिया रिगार्डिंग सर्विसेज ट्रांसफर एंड पोस्टिंग वुड नाउ नॉट बी अंडर द परव्यू ऑफ दिल्ली लेजिस्लेचर एंड ऑल्सो दिल्ली गवर्नमेंट. क्योंकि अगर लेजिस्लेचर के पावर है तो वो गवर्नमेंट के पास ही है, क्योंकि देयर इज अ ओवरलैप इंडिया में पार्लियामेंट्री सेटअप में. तो 2015 में सर्विसेज का कंट्रोल ले लिया गया फ्रॉम दिल्ली लेजिस्लेचर एंड एम्पावरिंग द एलजी टू डिस्चार्ज फंक्शंस ऑफ सेंट्रल गवर्नमेंट इन रिलेशन टू द सेम. सो एज फार एज सर्विसेज इज कंसर्न, इट वाज बीन सेड एलजी वुड बी टेकिंग ऑल द डिसीजन एंड ऑफ कोर्स ही वुड बी कंसल्टिंग द सेंट्रल गवर्नमेंट. In 2016, what happened? Delhi High Court holds that services lies outside the purview of Delhi Legislative Assembly and Executive. तो दिल्ली हाई कोर्ट ने मिनिस्ट्री के डिसीजन को अपहोल्ड कर दिया. मैटर वेंट टू हाई कोर्ट. सुप्रीम कोर्ट नहीं गया ना अभी, पहले हाई कोर्ट गया. सो हाई कोर्ट अपहोल्डेड दैट यस सर्विसेज शुड लाई आउटसाइड द परव्यू. एंड द रीजन इज व्हाट? क्योंकि दिल्ली में जो सर्विसेज प्रोवाइड कर रहे हैं वो यूपीएससी के थ्रू ही तो होती है ना. तो यूपीएससी में देयर इज दिस कार्डर नो व्हेन यू आर बीन अपॉइंटेड एज एन एज अ सिविल सर्वेंट इन यूटीज, तो वो तो सेंट्रल एजेंसी ने अपॉइंट किया है ना. सो फ्रॉम दैट लॉजिक दे वर सेइंग कि सर्विसेज शुड फॉल विद इन द सेंटर, राइट. इन 2018 व्हाट हैपेंड? अब ये मैटर चला गया, अब दिल्ली गवर्नमेंट लेके गई मैटर सुप्रीम कोर्ट. Supreme Court rules that LG must act on aid and advice of Council of Ministers of Delhi. Right? तो पहले तो ये बोला कि LG must act in aid and advice to the Council of Minister. Matter was continuing in Supreme Court. In 2019, a two-bench judgment of Supreme Court delivers a split verdict. यानी 1:1 का verdict हो गया. Two judges बैठे थे. So two judge bench of Supreme Court delivers a split verdict while ruling over the issue of services. यानी again the issue was in doldrum, है ना. Constitutional bench में कितने बैठते हैं मैंने बताया था? 5. And if it's not a constitutional matter तो आप 5 से कम में चला सकते हैं काम. So there were two judge bench. Problem यही हुई, two judge bench में था, split verdict आ गया. Again the matter was not resolved. Again the matter was there. 2021 what happened? Union government now amends the act altogether. Act 1991 जो था, Government National Capital Territory Act, that was being amended by Union government, expanding the list of matters where LG opinion is mandatory and the nature of bills that LG has to refer to the president. So they said, क्योंकि सेंटर और एलजी का दिल्ली का कॉन्फ्लिक्ट चल रहा था, दे सेड इट वुड बी बेटर इफ वी मेक एन अमेंडमेंट इन द बिल इटसेल्फ, एक्ट इटसेल्फ. तो एक्ट में ही चेंज कर दिया और कहा दैट नाउ द मैटर ऑन विच एलजी विल टेक अ मैंडेटरी ओपिनियन और एलजी's opinion becomes mandatory, list was elaborated and the nature of the bill which would be referred to the president, that list was also elaborated. This means this was a time when union was exhibiting itself more in Delhi. 2023 अभी भी मैटर सुप्रीम कोर्ट में ही है. Nature of bills that LG could refer to the president. So I told you, no, UTs में if the administrator feels that the nature of the bill is of high importance, then that bills could be referred directly to the president. तो यहाँ पर एक लिस्ट होती होगी with every UT. यहाँ पर they elaborated the list. So more number of bills now can be referred directly by LG to the center. 2023 में क्या होता है? Supreme Court rules that Delhi government has a control over services. So now Supreme Court came in favor of Delhi government. कब हुआ? 2023, last year, इसीलिए बड़ा controversial था. Now when Supreme Court rules in favor of Delhi government, what central government did? Central government now promulgates an ordinance. They have the power to issue ordinance. They promulgate an ordinance to amend the Act 1991. और एक्ट में उन्होंने ऑर्डिनेंस के थ्रू चेंज किया, एक्सक्लूडिंग सर्विसेज फ्रॉम द परव्यू ऑफ दिल्ली लेजिस्लेचर. So they said if Supreme Court is saying that Delhi government has a control over services, now what was the way out for the central government? Only way out की मैं issue कर देता हूँ ordinance. So an ordinance was being issued and seeking law and order situation, आप ordinance seek कर सकते हो exceptional situation में. So they issued an ordinance. An ordinance issue करते उन्होंने कह दिया services will be out from Delhi government purview. So subsequently Delhi National Capital Territory, the National Capital Territory of Delhi Amendment Bill 2023 was introduced in Lok Sabha to replace the ordinance. Ordinance को हमेशा आपको reform करना है within a law. So once the ordinance was being issued, now a bill was to be placed. So subsequent to the issuance of ordinance, similarly a bill on the same line was being placed in the Lok Sabha. So this was the trajectory, things which were happening. Now, Haji. See, okay, so should Supreme Court take it as a contempt of court? Contempt of court, Supreme Court will take when Supreme Court is guided only and only by its essential feature of delivering justice. If Supreme Court has delivered that this person must be hanged till death and then you are not executing that hanging, तो वो होगा Supreme Court का contempt. We need to figure out what is the essential function. यहाँ Supreme Court का, this was not something justice or seeking of justice. This was just an opinion which was being asked. Supreme Court gave its opinion. Of course, there was a case only, but this was not the core idea of grievance redressal. This is the reason government of course can come up, और government ने भी सिर्फ ऐसे ही violate नहीं किया. Government also took a legal course. So they issued an ordinance. Everything was legal. जैसे आप, if a question has come up into your mind, don't you think the question will come up in so many minds? So many legal heads would be involved. If Supreme Court itself will get involved. This is the reason government was very cautious. Government ने ordinance pass किया. Ordinance के बाद bill pass किया. Right? Now what happened? So now the bill has been passed. हम यहाँ तक पहुंचे हैं. एक बार फिर से रिवाइज करते हैं. 2019, two-judge bench of Supreme Court delivered a split verdict on the aspect of who controls services in Delhi. And now when the split judgment came up, और detail में है ये ideas, it was now referred to a three-bench judge. क्योंकि two-bench judge से तो justice was not there. So this was in 2019. 2022 में now the three-bench Supreme Court judgment comes up. A three-bench judge referred this case to a larger bench now on central government's plea. Central government ने कहा इसको larger bench तो लाओ. The three-bench judge had decided that the question of control over administrative services required further examination. So from two-bench it went to three-bench. Three-bench में Supreme Court said it requires further examination. Center was also demanding for a larger bench. So subsequently the matter again went to Supreme Court. This was May 2022 initial days. This is 11th May 2023 to be precise. While quoting Article 239AA, Supreme Court ruled that the elected government of National Capital Territory Delhi has legislative and executive power over the services under entry 41 list 2 of the 7th schedule. Also, this particular Supreme Court verdict in May said that LG is bound by the aid and advice of the Council of Ministers. So ये था Supreme Court का verdict. ठीक है, तो सेकेंड बेंच से थर्ड बेंच आया, थर्ड बेंच के बाद और इलेबोरेट बेंच आया, इलेबोरेट बेंच मेड अ डिसीजन इन फेवर ऑफ दिल्ली गवर्नमेंट, not only gave services to them, even said ki LG is bound to work in aid and advice with CM and Council of Minister. Now what happened? See what was the timeline and how quick central government was, because they knew this kind of verdict is going to come up, hai na? See, all these ideas you can write. When a question comes up, to what extent there is judicial independence or neutrality, this is one idea which showcases, yes, there is judicial independence. When judiciary actually has gone against its earlier verdict, which went in favor of central government, and it again came back to the verdict and went in favor of Delhi government. So now government of the day is very quick. 11th मई को सुप्रीम कोर्ट का वर्डिक्ट आता है, 19th मई को एक ऑर्डिनेंस आ जाता है. Central government now issues an ordinance which seeks to amend the Act of 1991. Ordinance nullifies the effect of the recent 2023 Supreme Court decision that gave Delhi government powers over services, excluding public order, police and land. ये तो वैसे भी नहीं मिल रहा था, ये तो है ही नहीं ना, because it's clearly written in Article 239 AA. इसके लिए तो conflict है, but the entire matter this time was regarding services. So they of course nullify, this ordinance nullifies the effect of Supreme Court verdict. Let's figure out what were the key aspects of ordinances. So power to legislate over services को लेके what does ordinance says? Ordinance specifies that Delhi Legislative Assembly will not have the power to legislate on subjects of services which comes under state list. Services include matters related to appointment and transfer of employees of Delhi government and vigilance. ठीक है, तो Delhi government के जितने employees होंगे, of course, यानी administrator, civil servants. So for their appointment and their transfer, everything would be under center control. National Capital Civil Service Authority. अब इसके लिए a new authority was created. क्योंकि अगर सब कुछ सेंटर के अंदर रख लोगे तो it would be considered to be a violation of a federal aspect. तो central government ने क्या कहा कि we are going to create a stipulated authority which will look into services. So herein now, as part of this ordinance, a new statutory authority came up. So prelims में question आ सकता है, National Capital Civil Service Authority, it is a constitutional body? No, it is a statutory body, because it came as a part of an act. So an ordinance, है ना, ordinance or act. So in order to make recommendations to LG regarding transfer, posting, vigilance and other incidental matter, now there was a statutory body which was created according to this ordinance. This particular body, अब देखो body का composition is very interesting. The body will consist of CM of Delhi, who shall be the chairperson, right? It will also consist of Chief Secretary and also Principal Secretary of Home Ministry. So if you look into the composition, सारा जो issue आया वो composition पे भी आया. Don't you think composition is bit, problematic? No doubt, आपने दिल्ली के CM को chairperson बना दिया, but the other two members are strictly under central ministry. वो भी central ministry के top civil servants हैं, chief secretary and principal secretary, right? All matters required to be decided by this authority, up comes the catch. It would be decided by majority of the votes of the members present and voting. So majority means if there are 3 people, 2:1 would be the majority. है ना, 3 को तो हम consensus मान लेंगे, 3 के बाद 2:1 का ratio होगा. So if 2 are agreeing, of course it would be considered that decision is taken. 2 जो agree करेंगे वो most likely agree करेंगे chief secretary and principal secretary, because they of course would be towing down to the central government or ministry's direction. This was again an issue. in this ordinance. ठीक है? The central government will appoint both principal secretary and chief secretary. So what was the point of making CM the chairman? यही controversy है. And you are going to write, देखो इसमें कुछ भी don't, many of the student, जब when I take FC classes, many of the student feel that ma'am should we criticize this? तो जो criticism के लायक हैं ideas, you should criticize because UPSC is giving you an opportunity to write your views in a rational way. So everything which comes within rationality is subject to put under scrutiny. And you should put it. हाँ, अगर वीटो पावर जैसा कुछ दे देते सीएम को तो दैट कुड हैव बीन गुड, लेकिन वो तो दिया नहीं. इट वाज बीन सेड डिसीजन वुड बी मेड बाय मेजॉरिटी. Next, what happened? So this is one idea, of course subject to criticism. Powers of lieutenant governor. So this ordinance said that LG will act in his sole discretion. It expands the discretionary power of the LG by giving him powers to approve the recommendation of these authority or even return it for reconsideration. So suppose a matter get decided on services regarding transfer and posting of Delhi government employees. Any decision by this authority will of course come to LG for final decision, final orders. LG in this regard would be the sole discretionary person. He is not working in aid and advice of CM or Council of Minister. क्योंकि CM तो इस commission का chairman है ही. So you are not going to refer back to CM. So you are working in your own discretion. And इतना ज़्यादा discretion है that you have the sole discretion to approve either the recommendation, and if you feel recommendations are not fine, you can again send it back to reconsideration. अभी देखो, here again is the catch. LG is a central agent. Suppose least case में माना गया कि यहाँ पर verdict CM और कोई एक officer ने has kept his integrity more intact and he has come up with CM. Suppose the decision now is in favor of Delhi government. That decision will go to LG. अभी तो फिर भी LG के पास chance है ना to send it back to reconsideration. So this was also one very important idea, how greater role of center was being put as far as services in Delhi is concerned. LG's decision will be final also in case of difference of opinion between him and authority C. Suppose reconsideration के बाद again matter comes up. Again these two persons are saying one thing and suppose another person is saying something different. अभी फिर से the matter will come to LG and in this case LG will take the final call. And LG of course would be a central appointee. Right? So this was a very, full of catch. This ordinance came out. No doubt it was put under scrutiny. तो अब ये मई में आया ordinance. And August May, once the ordinance was being made, after that this ordinance was of course put to, in form of bill, it was put before the parliament and parliament passed this particular act 2023. So act was duly passed. This particular act now repeals the ordinance, right? Abhi to act ban gaya, so it will repeal the ordinance. The ordinance giving Delhi Lieutenant Governor more power over Delhi government was issued after the decision of this particular case. Right? तो ordinance कब आया? जब Supreme Court का verdict against चला गया. Right? The question before the court was whether Delhi government headed by elected chief minister or LG appointed by president, who should have a control over services or civil servants. ये issue था Supreme Court के सामने. Just a few again recap. Supreme Court granted that government of Delhi should have a complete command over most of the services except these three, that is public order, land and police, over which central government will have exclusive power. ये Supreme Court ने verdict दिया early weeks May 2023. In 2018, Supreme Court ruled that LG did not had independent decision-making power and was bound to follow the aid and advice of COM. So actually, Supreme Court in 2023 has rested its ideas on the basis of its earlier verdict in 2018. और 2018 में सुप्रीम कोर्ट ने कहा था एलजी डज नॉट हैव अ डिस्क्रिशनरी पावर, इट हैज टू वर्क इन एडवाइस विद काउंसिल ऑफ मिनिस्टर. Except for these three powers, to which of course matter will directly via LG go to the president, बाकी सभी matters में LG will work in consonance with COM. This is the reason on the basis of which 2023 में Supreme Court made a verdict in favor of Delhi government. Government issued an ordinance. Ordinance turned into a bill in August 2023, turned into an act. Now, act के main provision क्या थे? So, as I have already discussed, there was a National Capital Civil Service Authority. So act में भी authority was there. So जो ordinance का idea था, they got replicated in act. This particular authority, the central government will appoint principal home secretary and chief secretary. All decisions of this authority will be made by majority. We have already discussed. Powers of LG would be of sole discretion. Matters outside legislative competence of Delhi Legislative Assembly but which will be delegated to LG. देखो इसमें लिखा कि कौन कौन से matters में LG may act solely on his discretion. When can LG act solely in his discretion? One, when matters outside the legislative competence of Delhi Legislative Assemblies have been delegated to LG. ये तो चलो ठीक है. So matters who are outside the legislative competence of assembly, अगर वो matters LG को दिए हैं तो of course LG will act in his discretion. Fine. Matters where he or she is required by act to law to act in his discretion or exercise any judicial or quasi-judicial functions. If there is certain act which also asks LG to do in same, LG will start working in his discretion. Primacy to LG. This particular act gave primacy to LG. The act expands the discretionary role of LG by giving him power to approve the recommendation of this authority, जो हमने अभी अभी देखा. So any such recommendation will come to LG, LG has to approve. In case of a difference of opinion between LG and this authority, LG's decision will be made final. So this was a way in which this ordinance turned out into an act. Few more ideas. Disposal of matters by ministers. Certain matters must be submitted to LG by the ministers of Delhi government through CM and Chief Secretary for his or her opinion prior to the issue of any order. So there would be certain matters which would be given to LG. By whom? By ministers of Delhi government, through chief minister and the chief secretary for his or her opinion prior to the issue of any order. What would be those proposals? It would be for peace of Delhi, it would be relations of Delhi government and central government, it would be summoning, prorogation, dissolution of legislative assembly, it would be matters on which LG is to give an order on his sole discretion. So as far as these matters are concerned, these matters must be submitted to the LG by ministers of Delhi government. Through whom? Through either chief minister or chief secretary. हाँ जी. How could summon prorogation and dissolution of legislative assembly? So how could he summon or prorogue? No. So idea is matter regarding it must be submitted. It is not written, it will be done by LG. LG of course can refer this matter to president. क्योंकि without president he is not doing anything. So देखो दो तरह के matters होंगे ना. एक matter होगा दिल्ली में which would be disposed entirely by CM and Legislative Assembly. Council of Ministers, Delhi Assembly will be concerned. कुछ matters ऐसे होंगे as we have already discussed like this, which would be deliberately, definitely be referred to LG. I'm not saying LG will be taking action. These matters would be reserved for LG. कौन reserve करेगा? Either CM can give or Chief Secretary can give. ठीक है? Duties of Secretary क्या होंगी? The concerned department secretary must bring, अब ये भी बहुत important idea था. The concerned department secretary must bring certain matters that may bring Delhi government into controversy to the notice of LG, the chief minister and the chief secretary. So this act says कि कोई भी डिपार्टमेंट, देयर वुड बी डिपार्टमेंट नो, किसी भी गवर्नमेंट एडमिनिस्ट्रेशन में you will be joining some or the other department only. When you will get promoted, then you will become department secretary. ठीक है, joint secretary होता है, फिर additional secretary होते हैं, फिर secretary होते हैं, right? So this would be the chrono. So this particular department secretary ideally क्या करते हैं? If you are a secretary to a department, you are first liable to the minister of that department. You are not liable to any other person. But as per this particular act, this chain would be violated. Kaise? Now this department secretary will bring certain matters which may bring Delhi government into controversy, not to his minister, but he can take this matter to LG directly, the chief minister or chief secretary. Right? So either he can go to his chief secretary, civil services ka head hoga. Either he will take the matter directly to this. Abhi chief secretary is of course a central appointee. No point. He can take this matter to LG. LG is a central appointee. Least case mein he will take the matter to CM. But the probability is very low. ठीक है? If you look into these matters, here also you will find certain matters like this would be directly submitted to LG by ministers of Delhi government. Hardly होगा ऐसा कोई कि ministers of Delhi government will do, लेकिन लिखा है through chief minister and chief secretary for his opinion. This is the reason. देखो ये लिखना उनकी liability थी, अब इतना भी नहीं बना देंगे ना कि everything will be pro center. You have to show the world also, no, कि things are balanced. So they are saying कि regarding these matters, LG opinion would be required. ये बात LG तक कैसे पहुंचेगी? ये बात LG तक पहुंचेगी through Delhi government by any of the minister or by chief minister or by chief secretary. So in rarest of the rare case or in any kind of cases, if they are not referring, chief secretary is always there to refer. यहाँ पर it is being said, if there is a departmental matter which is of urgent importance, this department secretary will not refer it to the concerned minister, जो कि technically Delhi government का minister होगा. You getting the catch? He will not refer it to the minister. He will directly refer it either to the LG or to the chief minister or to his administrative head. These were few of the reasons why this particular bill, later which became an act, was highly condemned and criticized. So now, as far as this particular act is concerned, what are the most important issues? एक काम करते हैं, issues अभी काफी लंबे हैं, and then we would be discussing tribunal. Let's take a break. After break, we are going to first decode कि ये पूरा issue है क्या. Now तो we know most of the things. Let's try to figure it out with certain concepts like chain of accountability and all. And after that, we will be moving to the second head of today's discussion. That would be tribunal. ठीक है? CAT देखेंगे, SAT देखेंगे, NGT देखेंगे, and few more tribunals. So online student must be thinking what I am saying. No, I was interacting with my offline student. So today you people didn't came up. This is the reason I was extra interacting with them. So tomorrow is going to be our last class. So I request all my dear online student to come up and join, so that for once last time, at least for the sessions we are meeting. But anyhow, I'm always there for help. No problem in that. Chalo. So now we have already discussed what was the recent act regarding the National Capital Territory of Delhi. And what were the issues? Abhi, what all I have written, basically this is an idea for prelims. But if suppose a question regarding triple chain accountability comes up in prelims, because it was very much into news, this is the reason I have included this idea. Let's see what was the main issue concerning this act. The first is powers to the central government. The act gives central government control over transfer and posting of officers in Delhi. So all kind of power as far as services are concerned has now been given to the central government. This is one issue. And another issue is, as you said, no, this is departure from Supreme Court's judgment in May 2023. This is the reason I made you people understand the chrono also. That in May, this kind of judgment from Supreme Court came up, ordinance came up immediately within 6 days, and then ordinance was being placed as bill and bill got passed. So no doubt it was departure from the previous Supreme Court judgment. Second issue is, it is argued that the issue is that meeting of this particular commission can be convened even without the presence of CM, as the quorum mandates 2 members. So what is the next issue? The next issue is that this kind of committee which is being set up for dealing and deciding on cases of transfer and posting, which would be a 3-member committee, wherein CM will be the chairperson, one of course would be chief secretary, another of course would be principal secretary, both would be from Department of Ministry of Home Affairs. But the issue is that as far as quorum is concerned, 2 members se bhi quorum chal jayega. Second, there is no necessity that CM compulsorily have to be present. यानी quorum में भी ऐसा नहीं है कि 2 members out of which 1 member have to be CM. ऐसा भी होता तो भी कुछ समझ आता. This is not something there. This means even if the other 2 administrators, chief secretary or principal secretary are present, then also the meeting can start. Right? So this is also one issue. Another very important issue is issue concerning the triple chain of accountability. Now, what is the triple chain of accountability? In a democratic system, it is being said there is a triple chain. Conferring power over the transfer and posting of officers as far as this committee is concerned may break the triple chain of accountability. How? According to Supreme Court, abhi Supreme Court has said in its verdict, this is the reason it came up into news. Supreme Court said that democratic government has a triple chain of accountability. ठीक है? Wherein civil servants are accountable to ministers. So what is triple chain of accountability? Civil servants are accountable to ministers. Right? Ministers are accountable to legislatures, and legislature is accountable to people, that is electorate. यही होती है triple chain of accountability in a democratic system. That civil servant, the post for which you people are appearing, you would be accountable to ministers, ministers would be accountable to legislature, legislature would be accountable to people. Else, आप ही बताओ, how would civil servants be accountable? We say no, that civil servants should also be accountable. कैसे हो सकते हो आप accountable? Because you are not an elected people. So there is an indirect accountability. You would be attached to some or the other minister or department. You would be accountable to that minister. That minister would be accountable to the lower house. And that legislature would be accountable ultimately to people. So there is always this triple chain of accountability. Now, as far as this particular act is concerned, Supreme Court even said that this is basically a violation of this triple chain of accountability. The act contradicts the first link. The act contradicts the first link as it violates the principle of parliamentary democracy, which is the basic structure of doctrine. How does you know that this act actually violates the first idea? Kaise? So I told you, when we were discussing before, that if there is any such issue regarding the subject, then the particular civil servant won't be addressing it to the concerned minister. He can take this matter directly to the LG or directly to the chief secretary. Technically, usko matter le jana hai apne department minister ko, but he is not doing so. So in this way, it is actually violating the triple chain of accountability. It also violates collective responsibility. Once it is violating the triple chain of accountability, it is violating the collective responsibility also. How? The department secretary, as I told you, technically department secretary means civil servant of a department in Delhi. Technically, he should bring the matter to the concerned minister. वही तो है ना, triple chain of accountability. You are responsible to the minister under whom you are working. Minister will put this in front of legislature. Legislature is accountable to people. लेकिन ये act क्या कह रहा है? That a department secretary can bring the matter directly to LG, directly to chief minister, and even to chief secretary. So somehow that loop of minister is being bypassed. So it is being said it is not only violative of triple chain of accountability, it is also violating the accountability, responsibility, that is collective responsibility. Another issue as far as this particular act is concerned is it enhanced the discretion of LG of Delhi. The provision of the act has expanded the discretionary and the overriding power of LG. And last is non-clarity on constitutional matters. The act provides for bringing certain matter to the notice of LG, but it is not at all written that what would be those certain matters which can be brought to LG. कहा है certain orders on the basis of order will be brought to LG. तो वो तो कोई भी matter हो सकते हैं. So there is no such clarity which matter would be taken forward by LG. ठीक है? So these are basically an idea given for your main side analysis. But of course, I thought that this thing regarding triple chain or this collective responsibility could be asked for your prelims. So now, before we move to the tribunal section, I have few questions and I would like to ask those questions. This is regarding state and union territory. So these questions already I have discussed, but again, tell me which will be or which is the first Indian state to have 3 capitals. Option is Andhra Pradesh, Uttarakhand, Jammu and Kashmir, Punjab. हम overall कर रहे हैं union territory या UT के ऊपर questions. So this is going to be Andhra Pradesh. It was the first state to have 3 capitals. It was Vishakhapatnam, which was an executive capital, Amravati, which was a legislative capital, and Kurnool, which is called the judicial capital. ठीक है? How many states are there in India right now? Easy option. 26, 28, 29, 27. Online student will also write 26, 28, 29, 27. 28 states, latest being Telangana. How many UTs are there? 6, 8, 7 or 9? How many UTs? 8. है ना? So this is Andaman Nicobar, Chandigarh, Dadar and Nagar Haveli and Daman and Diu एक साथ club हो गए हैं अब. But you see एक साथ एक club हो गया, but there are 2 UTs which have come up, no? So Jammu and Kashmir and Puducherry, Ladakh has also come up, and then there is Delhi, and then there is Lakshadweep as well. Which of the following state, अब state के ऊपर question, which of the following state is called God's own country? Kerala, very good. Which city is the center of India? So now this is quite interesting, even I found Nagpur, Bhopal, Rajpur or Raipur or Mumbai. No, it would be Nagpur. So Nagpur is considered to be winter capital of Maharashtra, tiger capital of India, and 0 mile marker hai. So this means exactly it is in the center of the country, right? Okay, अब जरा UT के ऊपर एक question है. Kindly tell me which of the following statements are correct. 1. Chandigarh is the capital of both Punjab and Haryana. Is it correct? Okay. Rajasthan is the largest state of India. Uttar Pradesh is most populous state. Kerala is the highest literacy. Yes, so all of them are correct. First idea is very important because of this reorganization and UT wala question we were discussing. Okay. UT were introduced in India in which year? 1949, 50, 56, 60. 56, this was state reorganization, 1956. After that, UTs were also being introduced. Few more questions on UT. The 25th Indian state to achieve statehood is? 25th state to achieve statehood. Options are Goa, Sikkim, Arunachal, Mizoram. Online student will also write 25th Indian state to achieve statehood is Goa. अब क्योंकि हमने गोवा कहीं पढ़ा नहीं है, I will be bit slow. You can note down also. So Goa is the 25th state of India. ठीक है? And we have discussed Puducherry, we have discussed Delhi. Goa रह गया था, तो I thought of discussing. So Goa is the 25th state of India. Earlier it was UT. 1987 में it became the 25th state of India. Before achieving this status of statehood, Goa was a UT. along with Daman and Diu. Then in Goa started this quest for statehood, and therein statehood status was being given to it. Earlier than this, Goa was under Portugal control for almost 450 years, in which year Goa was incorporated within India. 1961 through Indian Armed Force intervention, and post liberation Goa was not even made a separate UT. It was incorporated as a UT along with Daman and Diu. ठीक है, तो 61 में गोवा became and given a status of a UT, and 1987 में it became the 25th state of India. It must be, I think, Himachal. मैंने लिखा है that chrono I have already given. ठीक है, because chrono में question आते हैं. So if you remember, that is our lecture 2 where I have in chrono provided you which is what the year in which the state or the UT was there. तो काइंडली चेक दैट, है ना, इस तरह से चेक कर लो कि कौन सी ईयर से कौन सा है. एक और क्वेश्चन बताओ, इन विच स्टेट और यूटी इज दीवार आइलैंड सिचुएटेड? DIVAR. दिस वाज आल्सो इन न्यूज. दीवार आइलैंड सिचुएटेड. सत्यजीत इज राइटिंग इट करेक्ट. गोवा. बड़ी देर में सत्यजीत ने आंसर लिखा है. डजंट. अच्छा, आंसर फॉर दिस दीवार. वेरी नाइस. ओके, सो यस, क्योंकि पहले वाले का आंसर भी गोवा था ना, आई थॉट ही हैज रिटन इट. And I'm sure he is not bluffing. I mean, पहले वाले का आंसर तो नहीं लिख दिया. Anyways, whatever the idea is, Diwar is also being island situated in Goa. This is a small island which is situated near Mandovi River in Goa. So Mandovi River के पास है, and it is a quite a nice tourist attraction. Because of the environmental issues which are coming up, this has come up into news as well, right? So it's a very pristine, beautiful location. Okay, if I give you a statement, the statement is something like this: the parliament may by law form a new state by separating the territory from any state or unifying any territory as part of any state. ठीक है? Which of the following statement is true in this regard? One, on prior recommendation of president. Right? Second is on recommendation of president, who usually has to refer the bill to the legislatures of the state which is going to be affected. Who usually have to. लिखा है, हाँ? And third is by special majority in parliament, ratification by more than half of the state concerned. Simple majority. Is the second statement also correct? But the issue is, it is being written, he usually has. He usually, question में लिखा है, he usually have to refer it. It is not usually he has to refer it. It is, president is not bound to refer it. If it feels, he may refer. If he may not feel, he might not refer. In that sense, the second statement also is not correct. ठीक है? Okay, which of the following UT was given a partial statehood status in India? Partial statehood status, yeah, is given. Options are Chandigarh, Dadar and Nagar Haveli, Daman and Diu, Pondicherry. Puducherry is being given a partial statehood status in India. ठीक है? So complete statehood status is not given because we do have an idea of legislative assembly. So these are few more questions. अच्छा हाँ, एक और question करो. The jurisdiction of which of the following high court extends to? Oh, I thought something happened from this side. Okay. So jurisdiction of which of the following high court extends to Lakshadweep, Kerala, Tamil Nadu, Bombay or Delhi? Kerala. So Kerala, can you repeat, is prior recommendation of president required? Batao, Satyajit is asking. For placing a bill requiring changes of the territories of a state, is a prior recommendation of president required? This is regarding Article 3, है ना? So do you think, as far as 3 is concerned, we have to refer it to the president? No, prior recommendation, don't you think, question kya tha hamara, on prior recommendation of the president this kind of bill can be placed. So of course recommendation of president in this regard is required. भाई आप simple logic सोचो ना, recommendation क्यों require है, क्योंकि यहाँ state का हम view ले नहीं रहे हैं. You are not taking as view of the state. So you need to create an extra layer of protection. What if the central legislature start acting in an arbitrary way? So because you are not taking the consonance or the will of the state legislature, of course, then another layer of bracket is president. Because president is considered to be a representative of the entire country. And as you know, president ke election mein, electoral college mein, state legislative assemblies are also members allowed. है ना? This is the reason. तो प्रेसिडेंट का रिकमेंडेशन तो लिया जाता है, लेकिन स्टेट लेजिस्लेटिव असेंबलीज को इट इज नॉट considered necessary to refer the matter to them, right? वहां usually लिखा था ना, this is the reason it is not correct. Okay, so Anushri is saying yes required, yes it is required. अच्छा, मैंने क्या question पूछा था? What was the question I was asking? That where is Puducherry की, where does the ये High Court jurisdiction lies? So what is the correct answer? So as far as Lakshadweep is concerned, High Court jurisdiction is that of Kerala. ठीक है? Okay. So now this is all about UT. Next, because the issue is that I was not able to figure out for last 5 years any question on UT coming up. Else I would have provided it. है ना? Next is an idea concerning tribunals. Now, tribunal is of course a very important idea, though again I was not able to figure out any question in past 5 years regarding tribunal, but then tribunal of course always remains an evergreen important idea. Dekho what I have created, this is evolution of tribunal in India. And how was the evolution? So 1996 to mid 1970s. क्या आती है? This is the first Administrative Reform Commission coming up, first ARC. Now then the first ARC came up. What was the idea? So 1966 to 70s के बीच में all these committees are also being set up. So one, there is first ARC, and second there are few more committees. One was JC Shah committee. Remember मैंने एक दिन और भी आप लोगों को tribunals discuss किया था, wherein I mentioned about two important committees, Swarna Singh committee and JC Shah committee. So it was JC Shah committee 1969, then it was Swarna Singh committee 1976, and of course there was a recommendation in first ARC also, and now there was an idea that yes, tribunals needs to be made. In 1985, Administrative Tribunal Act 1985 was set up. In 1976, it was 42nd Constitutional Amendment Act. This, अब देखो 1976 में Swarna Singh committee came up. Both these two committees have already recommended that tribunals needs to be set up. So 42nd Constitutional Amendment आता है. As far as this amendment is concerned, it added part 14 of the Constitution. So tribunals कब आए? After 42nd Constitutional Amendment Act. क्या add किया? It added part 14 of the Constitution and two articles were added. Article 323A and Article 323B. Right? This happened in 1976. फिर क्या होता है? Now came 1985. Now there was Administrative Tribunal Act of 1985, which enabled setting up of Central Administrative Tribunal and also State Administrative Tribunal in order to empower the central government employees or any kind of civil servants who were, or administrators who were there, right? So this was basically the journey which was happening as far as tribunals are concerned. The committee recommended for the establishment of administrative tribunals. कौन सी committee? Be it JC Shah committee or the Swarna Singh committee. CAT is Central Administrative Tribunal and SAT is State Administrative Tribunal. So this is the entire idea. You can take it forward for your mains also. You can take it forward for your prelims as well. So now What are these two articles which came up after 42nd Constitutional Amendment? Article 323A deals with administrative tribunal and Article 323B deals with tribunals for other matters. ठीक है, तो एक होगा एडमिनिस्ट्रेटिव ट्राइब्यूनल, एक होगा कोई भी ट्राइब्यूनल फॉर सम अदर मैटर, जैसे एनजीटी है, नेशनल ग्रीन ट्राइब्यूनल, राइट? नाउ व्हाट आर द कैटेगरीज ऑफ ट्राइब्यूनल्स इन इंडिया? The first category are the administrative bodies which exercise quasi-judicial functions, whether as part and parcel of department or otherwise. So one could be administrative tribunals. Another could be administrative adjudicatory bodies who are outside the control of the department involved in the dispute and hence decide dispute as a judge which is free from judicial bias. These kind of administrative adjudicatory bodies could be like Income Tax Appellate Tribunal, which is under the Ministry of Law and not under the Ministry of Finance. So what are the categories? एक तो वो tribunal होती हैं which are attached to the department. They are part and parcel of the department, right? एक वो tribunals होती हैं which are not part of the department. They are acting in an independent way. However, they might be taking cases regarding those departments. For example, Income Tax Appellate Tribunal. So a question can come up that Income Tax Appellate Tribunal falls within which ministry? You would say it falls within Ministry of Law and not Ministry of Finance. The third type of tribunals are tribunals constituted under Article 323A and Article 323B, right? They are having a constitutional origin, क्योंकि now they are as per an article. So be it CAT, be it SAT, all have a constitutional origin. Though CAT and SAT has come out as a product of an act, so you can't say they are constitutional bodies. If you look into CAT and SAT, see, there was Administrative Tribunal Act 1985, which enabled creation of CAT and enabled state government also to establish SAT. So CAT and SAT do have a basis of constitution, but exactly they are statutory bodies. However, of course, these bodies do have an origin from certain article. ठीक है? So now we know there are three kinds of tribunals. एक वो होते हैं, भाई tribunal मतलब क्या है? Anything which is giving decision. कोई ना कोई grievance redressal हो रहा है. तो कुछ होती हैं tribunals which are attached to the department. कुछ हैं tribunals which are outside the department. For instance, the Income Tax Appellate Tribunal. And then there are certain tribunals which are on the basis of Article 323A and Article 323B, which have a constitutional origin. So these are the three categories of tribunals in India. Now the question is, so what is the difference between Article 323A and 323B? While 323A contemplates establishment of tribunals for public service matters, 323B contemplates establishment of tribunals for any other such matters such as taxation, foreign exchange, land reform, industry or labor reform. So first difference is 323A is only regarded to or related to public services. So public services, be it at the center, be it at the state, अगर public services का कोई issue है, you can have Article 323A to deal. Apart from public services, if you have some other matter, it will come under Article 323B. Second difference is, while tribunal under Article 323A can be established only by Parliament, tribunals under Article 323B, which is meant for other purposes, can be established both by Parliament and state legislature with respect to matters which are following within their legislative competence. Very simple hai कि since Article 323B deals with tribunals dealing with any other matter, तो अगर वो any other matter comes within state list, तो state legislature can make such tribunal. If that matter comes under union list, then center can make such tribunal, right? However, as far as 323A is concerned, only Parliament has the power to create tribunals. Third difference is, under Article 323A, only one tribunal for center and one for each state or two or more state can be established. So only one tribunal would be established. जिसको कैट कहेंगे या स्टेट या कलेक्टिव स्टेट होंगे तो सैट कहेंगे. देयर इज नो क्वेश्चन ऑफ हायरार्की ऑफ ट्राइब्यूनल्स. ऐसा नहीं है कि कैट से भी ऊपर कोई ट्राइब्यूनल बन जाएगा. नो, देयर इज ओनली वन ट्राइब्यूनल. इट कुड बी कैट, इट कुड बी सैट इन टर्म्स ऑफ स्टेट. Whereas under Article 323B, if tribunals are set for any of these purposes, a hierarchy of tribunals can be created. So this could be a very nice idea for your mains also. Simple, straightforward, 100 marks question. Elaborate the history of evolution of tribunals in India. Elucidate the basic difference between Article 323A and Article 323B. भाई ये क्यों मान के चल रहे हो कि polity in mains में you will always be getting a difficult question. Most of the time difficult are just one or two, है ना. Most of the time 5-6 questions में से 3 questions or 4 questions would be manageable, जो directly पूछे जाएंगे. So this is a very fine idea for that. Next is some other tribunals for settling various administrative and tax related disputes. So हमने कहा ना कि कुछ tribunals 323A में तो हैं CAT और SAT. And then comes some other tribunals under Article 323B. What could be those some other tribunals? These are some other tribunals. Like Income Tax Appellate Tribunal, NJT, Security Appellate Tribunal, Armed Force Tribunal, Water Dispute Tribunal, Competition Appellate Tribunal, Custom Excise and Service Tax Appellate Tribunal. ठीक है? So these are few more administrative or tax related tribunal. What are the characteristics of tribunal? First, see, as far as the tribunals are concerned, they will always follow the principle of natural justice. What is the principle of natural justice? Rather than focusing purely on laws of the state, आगे they would focus more on okay. So आपको क्या कहना है? Anything more? क्योंकि इसी के बाद next idea आता है that to what they are abiding to. So natural justice is dealing with the principles of, as far as nature is concerned, nature ka principle itself, because see, nature does not tend to create any kind of discrimination. So natural justice ka most important idea is that we should always act, or justice should always be given fairly. This is the first idea regarding natural justice. Justice needs to be given without any kind of bias. So justice against bias or justice without bias became one of the very important idea regarding natural justice. ये prelims में question आ सकता है, which of the following are criterias of natural justice, है ना? So first criteria is that there would be an idea against bias. Second is, in a natural justice, the person who is implicated is given the right of hearing, right? So natural justice gives a right to fair hearing. So these are few of the ideas: absence of discrimination, absence of biasness, right to fair hearing. These are the ideas of natural justice, right? So now these tribunals follow the principle of natural justice, and since they follow the principle of natural justice, इसलिए मैंने कहा इसी से related है next point, they are not bounded by strict rules of civil procedure code. CPC से ये rules binded नहीं है इनके, ठीक है? Next, state performs quasi judicial functions. So in this particular tribunal, it has been stated that they perform quasi-judicial function. Quasi-judicial function का मतलब है इसमें purely they are not giving verdict whether you are proven guilty or not, जो कि pure judiciary का काम है. They are also not interpreting the constitution. They are also not safeguarding your fundamental right. So few ideas regarding judicial system क्या है. Hearing होगी इनमें. Hearing will be based upon natural justice. They will even have an idea of summoning also. They can even ask for evidence also. इसको कहते हैं quasi judicial functions, right? And creation of a statute. So tribunal is always being a part or it is a product when a statute or an act comes up. जैसे कि Central Administrative Tribunal CAT, State Administrative Tribunal SAT, National Green Tribunal NJT, they are always an administrative act. They are result of an act. तो आर्टिकल की वजह से एक एक्ट बन रहा है. So all they are statutory bodies, right? So these are the characteristic of tribunals. Now we are going to discuss few important tribunal. One of course would be CAT. When was CAT established? CAT was established in 1985 with the principal bench at Delhi and additional benches were there in different state. So 1985 में ही, if you look into this history, you will figure out in 1985 Administrative Tribunal Act was made. This enabled the center to set up CAT, and this also enables that central government can order for the creation of SAT. This is the reason CAT came into existence in 1985. Central bench इसकी Delhi बना दी गई and additional benches were made in other parts. Now presently there are 18 benches wherein hearing as far as central servants are concerned, जो central civil service के central employees हैं, if they have a grievance that could be heard in CAT. इसीलिए तो CAT बना है, नहीं? तो अभी total 18 benches हो गए. क्वेश्चन आ सकता है कि एक तो एट प्रेजेंट कितनी बेंचेस हैं. यू विल से 18. रीजन क्यों? बिकॉज लेटेस्ट वन इज फॉर यूटी ऑफ जम्मू एंड कश्मीर एंड लद्दाख. तो लद्दाख और JNK के लिए एक ही बेंच बना दी गई. सो इनिशियली इट वाज 17 बेंचेस, टुडे इट इज 18 बेंचेस. बेंचेस मस्ट बी जम्मू एंड कश्मीर में ही होगी, लद्दाख में तो नहीं. इट वुड, द सेंटर मस्ट बी जम्मू एंड कश्मीर ओनली. Some other tribunals for settling various administrative and tax related disputes are, and now these are few more जो हमने already उस map में देख लिया. So these are few more central administrative tribunals which are being made. Few more tribunals, sorry. What is the jurisdiction? CAT exercises original jurisdiction. So I told you जब हमने Supreme Court पढ़ा था कि original jurisdiction is not, are High Court having original jurisdiction? है ना? So even High Court is having original jurisdiction. High Court is having original jurisdiction even in the cases of when fundamental rights are being violated. Writ jurisdiction तो High Court की भी है. तो द पॉइंट इज ओरिजिनल जुरिस्डिक्शन का मतलब ये नहीं है कि ओरिजिनल जुरिस्डिक्शन मींस इट इज एक्सक्लूसिव जुरिस्डिक्शन ऑफ सुप्रीम कोर्ट. नो, मैंने उस दिन भी समझाया था ओरिजिनल जुरिस्डिक्शन मतलब ओरिजिनली फॉर द फर्स्ट टाइम व्हेन दैट केस इज कमिंग. ओरिजिनली फॉर द फर्स्ट टाइम व्हेन अ केस इज कमिंग टू हाई कोर्ट तो वो हाई कोर्ट की ओरिजिनल जुरिस्डिक्शन हो जाएगी. ओरिजिनली व्हेन अंडर आर्टिकल 32 अ केस इज कमिंग टू सुप्रीम कोर्ट इट बिकम्स ओरिजिनल जुरिस्डिक्शन ऑफ सुप्रीम कोर्ट. सिमिलरली कैट आल्सो हैव ओरिजिनल जुरिस्डिक्शन. Because if you are having certain administrative issue, you will go to CAT only. So in relation to recruitment and all service conditions of public servants, so when you will become public servant, if now you are having some recruitment related or you are having some public service matter related, you can put your grievance originally to CAT. So this is a central administrative tribunal. What is the composition of CAT? CAT is a multi-membered body consisting of a chairman and member. At present, it is 65. A chairman is a sitting or a retired judge of a high court, not Supreme Court. With amendment in Administrative Tribunal Act in 2006, members have been given a status of the judge of a high court. ये मैंने उस दिन भी बताया था. They are just being given the status. They might not be, but status unko by the time they are having their tenure in CAT, they would be considered, or they will enjoy that status of a judge of a high court. They are drawn from both judicial and administrative streams and are appointed by president. ठीक है? This means याद करने के लिए आप समझ जाना कि CAT के membership में it's nothing to do with Supreme Court. Right? Judges from High Court only are coming up. Either, so chairman would definitely be from High Court, and other members could be from judicial. That is, they can be taken up from High Court. Also, they could come up from administrative stream. By administrative stream to rakhna padega, because service matter to an administrative person will know, no? So CAT में होंगे service matter. लेकिन if they are from administrative stream, till the time they are serving within CAT, they would be given the status of judges of High Court. Appeal against CAT orders. The appeal against the orders of an administrative tribunal shall lie before the division bench of the concerned High Court. This is what Chandra Kumar case 1997 says. Means this is not a area beyond which you cannot appeal. No. CAT के पास original jurisdiction है, but CAT के पास absolute नहीं है. So grievances from CAT can go forward, but they can just go forward to the concerned division bench of the nearest High Court. ठीक है? So High Court would be taking forward the appeal. So appellate jurisdiction चला जाएगा concerned High Court को. Now comes SAT. What is SAT? The Administrative Tribunal Act 1985, just like it has empowered central government to create CAT, it empowers central government to establish SAT also. Antar itna hai, this is Central Administrative Tribunal, this is State Administrative Tribunal, on specific request of the concerned state government. So of course state government will make a request in order to Okay, naam bolo beta. Nidhi is asking for online. I am repeating. And Nidhi is asking that if the matter on appeal goes to the concerned High Court, then High Court also have the, see the point. So she is asking High Court will also have the members of High Court, of course, and CAT is also having members of High Court. Look into the composition again of CAT. So CAT ka composition kya hai? Members have been given the status of judges of High Court, and they can be drawn from judicial stream, they can be drawn for administrative stream, but it is not written that they will be drawn from the judicial stream of the concerned High Court only. Who said? ऐसा तो नहीं लिखा है, right? हाँ? So एक तो ये है कि CAT का composition is different. It is including administrative people also. It is including judicial people also. Judicial people, your concern is कि वो उसी High Court से तो judicial people आए हैं. No, it's not necessary. वो तो कहीं पे भी नहीं लिखा. Judicial stream से आने चाहिए बस. कौन से हाई कोर्ट से है ये तो लिखा नहीं है ना, क्योंकि ये तो सेंट्रल एडमिनिस्ट्रेटिव ट्रिब्यूनल है ना भाई. दिस इज नॉट स्टेट. ओके, सो शी इज सेइंग कि यहाँ पर डाइवर्सिटी है बिकॉज एडमिनिस्ट्रेटिव मेंबर्स आर देयर बट देयर आर जस्ट जुडिशियल मेंबर्स. सो द पॉइंट इज दैट सिंस यू आर नॉट satisfied with this diverse composition only, then you would be making an appeal to High Court. Right? So now you don't have any choice saying I want again diversity. Agar diversity chahiye of opinion, then be okay with the decision what CAT has given. You can't have another similar body, no? Then what's the point of making an appeal? CAT jaisi body ko maine appealing bhi bana di, so what is the point? So appealing body is always more narrow in nature, है ना? Lower body is more broader in nature. तो पहले broader थी, CAT भी थे, administrative people were there, but you are not satisfied. So now you are making an appeal to a much narrow body. वो narrow होगी from high court. ठीक है? Yeah, that decision would be taken. क्योंकि अब उसके beyond कहाँ जा रहा है? इसके beyond तो नहीं हो रही appeal, right? So this is going to, the appeal against the order can be laid only before the division bench of the concerned high court. Why? Why can't single bench in the sense? So, okay. So Bharadwaj, no? Bharadwaj is asking why division bench, why not single bench? So the point is that now we don't have any other option beyond this. This is the reason I now want decision to be done. So I can't put a single bench saying that only one. What if you are not good enough, or you are not able to, you are not accepting, or you feel that your judgment is not coming good? तो एक single judge को मैं क्यों रखूं? This is the reason once for all, when you are appealing, a division bench is being made, right? More than 1-2 members being taken up. Next is SAT. SAT में भी क्या है? Central government will establish SAT, that is State Administrative Tribunal, but this time special request will be taken from the concerned state government. तो question आ सकता है, central government will establish SAT या state government? So prelims में this could be a catch. You will say central government. The chairman and the members of SAT are all appointed by president after consultation with governor of the state concerned. Of course, जब मैं कह रही हूँ central government is empowered, तो central government तो एक larger idea हो गया ना. Face central government का तो appointment के लिए president होता है. So wherever you are figuring out central government, you should always think कि appointment will be given to president. Because central government is what? It is just an idea. Who is the appointing authority as far as central government is concerned? President. Prime Minister के पास तो कोई भी executive power नहीं है. Do Prime Minister have any executive power in terms of appointment? No. Right? So it would be president, but of course he would be consulting the concerned governor. Now as far as NGT is concerned, it was established in year 2010. And this was under the NGT Act 2010. So NGT is another form of other types of tribunal जो हमने देखा था ना, उसमें से one example is that of NGT. For effective and expeditious disposal of cases concerning environmental protection and conservation of forest. India became the third country in the world to set up a specialized environmental tribunal only after Australia and New Zealand. So India is the third country to take forward an idea like National Green Tribunal. First country is Australia and second country is New Zealand. New Delhi is NGT's principal bench, with Bhopal, Pune, Kolkata, Chennai being the other benches. So this question also often comes up in exam. Now what is the composition of NGT? Tribunal comprises of chairman. Chairman would be appointed by central government. If a question says chairman would be appointed by president, that would also be correct, in consultation with Chief Justice of India. Okay? The judicial members, only an existing or a retired judge of a high court or a Supreme Court can become judicial members of NGT. This means NGT के अंदर Supreme Court का idea will come up. For CAT, it was only about high courts. So here judicial member could be only an existing or a retired, right? And expert members are related to environment field क्योंकि उनको तो domain expert होना है. These domain experts will have 15 years of administrative experience. So NGT का है, there would be a chairman, there would be judicial members, there would be experts. Experts 15 years experience, judicial members running or retired judges of Supreme Court or High Court. Note, chairperson, the judicial members and the expert members shall hold the office for a term of 5 years and they are not eligible for reappointment. Okay? So definitely they are not eligible for reappointment, एंड ऑल दीज. तो इनफैक्ट एक्सपर्ट मेंबर्स ऑल्सो जो 15 ईयर्स के टर्म्स के होते हैं, उनका 5 ईयर का टर्म है, इसका मतलब दे आर नॉट एलिजिबल फॉर रीअपॉइंटमेंट इन एनजीटी अगेन. डोंट गेट कंफ्यूज. वेरेवर दे आर वर्किंग, सपोज ये लोग हैं हाई कोर्ट और सुप्रीम कोर्ट के, तो ये 5 साल यहाँ टर्म करके वापस चले जाएंगे अपने कंसर्न डोमेन में, एनजीटी में दोबारा नहीं आएंगे रीअपॉइंटमेंट. ठीक है. सो दिस मीन्स एनजीटी का टर्म विल बी ऑफ 5 years. Now, what is the jurisdiction of NGT? NGT adjudicate matters relating to following legislation. This is exactly a type of question which sometime have come up. This is the reason I thought I will write all the acts which are dealing with NGT, which NGT deals. So this is water, forest, air, environment. इतना तो आप लोग समझ ही जाएंगे. Biological diversity, okay, fine, you will tick it. The only difference is Public Liability Insurance Act 1991. So NGT is also dealing with this idea of Public Liability Insurance Act. ये बस थोड़ा सा डिफरेंट है, बाकी सारे आइडियाज अगर आएंगे यू विल बी मार्किंग इट टिक. ठीक है. सो नॉर्मली प्रीलिम्स के लिए कैसे याद करना चाहिए, कोई एक्सेप्शनल चीज दिख रही है तो काइंडली फिगर दिस आउट. NGT has not been vested with the power to hear any matter related to Wildlife Protection Act 1972 and Indian Forest Act 1927. This is an exceptional idea, because there is this act in which already provisions are being given that if somehow it is being violated, this would be the result for that. Okay? And NGT is mostly related with ideas regarding environment protection, pollution, water, air, soil. This is basically regarding conservation. This is more regarding conservation. ठीक है. यहाँ पर है water prevention, देखो pollution का idea है, forest conservation का idea है, environment protection का idea है. This is a core Wildlife Protection Act. This is Indian Forest Act. This have their own detailed ideas. This is the reason इनसे related कोई matter won't be taken up in NGT, so that there is no overlapping of functions done. What is the power and the functions of NGT first? So this is very obvious कि I already told you that जितनी भी tribunals होती हैं, they all are based upon natural justice. And since they are based upon natural justice, they are not guided by CPC. This is the reason it is written that NGT is not bounded by the procedure under Code of Civil Procedure. Right? 1908 or Indian Evidence Act 1872. Rather, it is also, because it is also one tribunal, it is guided by principle of natural justice. It is mandated to make disposal of applications or appeals finally within 6 months of filing the same. So suppose a matter has come up today, so mandatory hai to dispose this particular application within 6 months. Reason probably for NGT is that it is going to deal with pollution and environment cases, and you are not supposed to make it too much pending. So 6 months ke bhitar you have to dispose. Appeals from NGT lie directly to Supreme Court. Here, High Court is not an idea. Now you can understand कि composition को देखो तो there also you will figure out members coming from Supreme Court or High Court. An appeal, as far as NGT is concerned, it is not going to any of the High Court. It is directly going to Supreme Court. CAT की appeal is going to the division bench of the concerned High Court. Right? While passing any order, decision, award, it shall apply the principle of sustainable development, precautionary principle, and polluter pay principle. What do you mean by polluter pay principle? Who is polluting? That is responsible. So polluter pay principle pay, it is based on that only. It says that whosoever is responsible for contributing to pollution, onus of responsibility and burden lies on that only. ठीक है. Precautionary principle means, what do you mean by precautionary principle? Hmm. Hmm. So preemptive action would be taken before exactly something has happened, है ना? So even if government is coming up, or sorry, any power plant or something comes up, on preemptive basis also NGT can take a decision, है ना? So this is called precautionary principle, that NGT can say कि मैं इसमें hold लगाना चाहता हूँ, I don't want this thing to happen, right? And sustainable development, what do you mean by sustainable development? Hmm? Yes, sustainable development means when you are using or appropriating a resource, but at the same time, you are leaving a rest or a surplus for the future generation also to take up. Okay, so Satyajit is asking, ma'am, does division bench means a two bench judge of high court? Yes, division bench means कि at least two judges होने चाहिए. ठीक है, at least का idea है. Okay, Anushri has written for natural justice. Just, fair and right in any situation. Yes, absolutely correct. Next is NGT does not take the power to take, does not have the power to take suo motu cognizance. Means this matter is sub judice in Supreme Court. Okay? So the point is it does not have the power to take suo motu cognizance. यानी कि एनजीटी पर ये मैटर कहीं से आना चाहिए. इट कांट आउट ऑफ इट्स ओन विल टेक फॉरवर्ड एन आइडिया कि दिल्ली में बहुत पोल्यूशन है, एनजीटी कैन नॉट कम अप. ठीक है, सो दिस इज एन आइडिया. इट इज वेस्टेड विद द पावर ऑफ सिविल कोर्ट. इट इज वेस्टेड विद पावर ऑफ सिविल कोर्ट अंडर सीपीसी का मतलब सिविल कोर्ट की कौन सी पावर्स इट इज बीन देयर? When it is said it is it should be vested with the power of civil court, what does that mean? सो पहली बात तो सिविल कोर्ट जैसे ही आए तो कहोगे नॉन क्रिमिनल केसेस. सो दिस मीन्स एनजीटी इज ओनली डिस्कसिंग नॉन क्रिमिनल केसेस. नो डाउट ये जितने पोल्यूशन के केस हैं कोई क्रिमिनल केस के अंदर नहीं आएंगे. अनदर सिविल मैटर का मतलब होता है यू हैव द पावर टू समन, यू हैव द पावर टू टेक एविडेंस, यू इवन हैव पावर टू इम्पोज फाइन्स. ठीक है, सो दिस इज एन आइडिया. So this is all about tribunals, but then now I'm going to refer to some very important question. Kindly answer it. So first would be, what is the objective or the reason behind? Just normally I am asking क्योंकि ये normal वैसे भी see CAT वगैरह क्या है ना, these are very important idea not only for prelims but also later on for interviews. क्योंकि when you are referring to CAT, this means service conditions में कोई grievance तो anyone can have, no? So what is the main objective behind setting up of CAT if it is being said? So this, हाँ बोलो. Hmm. 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 So you, in just one line, you would say inexpensive. It is to provide affordable and speedy relief to central government employees as far as their grievances is concerned. ठीक है? Reduce, हाँ, this is also an alternative way to reduce burden on judiciary, because of course it would only be on an appeal that a decision will go to the high court, concerned high court. ठीक है? Now tell me, NGT Act was passed in year 2010, 5/8. It was passed in 2010. So next is, okay, which of the following is the principal place of sitting up of NGT? This is Kolkata, New Delhi, Lucknow. Principal place, New Delhi. Okay. In which of the city for the first time? अब थोड़ा different है क्योंकि alternate हम उसमें आ गए ना. Grievance, see, like what Anushri has also written to reduce the burden on the court. So we have talking about alternative ideas to reduce. So अब हम we can talk also about Lok Adalat. Tell me, in which of the city of India for the first time Lok Adalat was held? New Delhi, Chennai, Kolkata, Mumbai. In which of the city for the first time Lok Adalat was held in India? So option is New Delhi, Chennai, Kolkata, Mumbai. Online student भी लिखेंगे. So the first Lok Adalat in India was being set up in New Delhi. ठीक है? And this was set up in year 1982. Right? अच्छा. अब if I tell you, ये थोड़ा complicated हो जाएगा because, okay. So Dhanshi is saying New Delhi. Okay. Who appoints chairman of SAT? Governor, President, Chief Justice of High Court or National Judicial Commission? President. ठीक है, इसी तरह के options आएंगे. This is the reason I am taking these questions. Who is going to appoint the chairman of SAT? तो चाहे chairman of SAT हो, चाहे chairman of CAT हो, चाहे members हो, all would be appointed by. लिखा है central government, but face would be president, of course, right? उसमें National Judicial Commission का भी option हो सकता है. Okay. How many days an appeal can be made by an aggrieved person by a decision of NJT to Supreme Court? So it is 30 days, it is 45 days, it is 60 days, it is 90 days. Question is, I am again repeating online students के लिए, within how many days an appeal can be made by an aggrieved person by decision of NJT to Supreme Court. एक बार जरा वापस चलो देखो, mandated to make disposal of cases within 6 months of filing the same लिखा है. यहाँ पर है कि 6 month filing the case के बीच में NJT have to give the decision. My question is, if an appeal comes from NJT to Supreme Court, then how many days, within how many days an appeal can be made? So this correct answer is 90 days. So within 90 days an appeal has to be made. ठीक है? So any person seeking relief and compensation for environmental damages may approach the tribunal. Decision of the tribunal, of course, are enforceable as per the civil court. So they have the same, power as Supreme Court. And tribunal has the power to review its own decision. If this fails, then decision can be challenged before Supreme Court within 90 days. Very nice. Anushri is written at 90. Dhanshri is also saying 90. Excellent. ये एक point इसमें नहीं था. This is the reason I am taking forward. नहीं तो रिव्यू इस तरह से होगा ना कि इनके डिसीजन को अपील कर दिया जाएगा सुप्रीम कोर्ट. In that way it would be reviewed, right? It is subject to that review. Okay, I could have one more question. Now if एक last question है, अच्छे से सुनेंगे. How is NGT different from Central Pollution Control Board? So first point is NGT has been established by an act. ठीक है? Whereas Central Pollution Control Board has been created by an executive order. Second statement is NJT provides environmental justice and helps reduce the burden of litigation in the higher court. Whereas Central Pollution Control Board promotes cleanliness of streams and wells and aims to improve the quality of air in India. So 1, 2 or both 1 and 2. First statement ये कह रहा है, second statement तो clear है, सही है ना? Second statement कह रहा है कि भाई NGT का main काम है to provide environmental justice and to reduce the burden on the court. यही दो reason मैंने पूछे भी थे, अभी एक question में आया था. What is the main mandate of Central Pollution Control Board? The main mandate of Central Pollution Control Board is to promote cleanliness of streams, of wells, and since it is pollution control, तो जहां से pollution है, it could be air, it could be water, it could be soil. So उनका aim is to to reduce pollution, improve the quality of air. ठीक है? This second statement is absolutely correct. Issue हमको first statement में है. फर्स्ट स्टेटमेंट कह रहा है कि एनजीटी तो स्टैब्लिश हुआ एक्ट से, बट सीपीसीबी दैट इज सेंट्रल पोल्यूशन कंट्रोल बोर्ड हैज बीन क्रिएटेड बाय एन एग्जीक्यूटिव ऑर्डर. नाउ टेल मी वेदर इट इज क्रिएटेड बाय एन एग्जीक्यूटिव ऑर्डर, क्योंकि एनजीटी एक्ट से है ये भी क्लियर है. अभी हमारा इशू अब इसी तरह से प्रीलिम्स में देखो कि कहां कहां मुझे क्लैरिटी मिल रही है. So second statement is absolutely correct. I have an issue with first statement. First statement partially it appears to be correct because NGT is a result of a statute, right? What about Central Pollution Control Board? So this is also a statutory organization, right? This is a statutory organization which was being established in September 1974. This was as part of Water Prevention and Control of Pollution Act 1974. So it is not through an executive order, it is also through a proper act which was formed. So both NGT as well as Central Pollution Control Board, which is so much into news, this is the reason I took this question, both of them are statutory organizations, right? अच्छा, एक और question बड़ा interesting है. So there are one statement, the power to constitute foreign tribunals is vested only with district magistrate. Second statement, they are set up under Citizenship Act 1955. Foreigners Tribunal. You remember मैंने Foreigners Tribunal discuss किया था when I was discussing citizenship. क्योंकि tribunals discuss कर रहे हैं तो this is the reason I have put this question also. So I told you कि India में we don't have a specific refugee policy. बताया था. And then I said that there are just two important ideas which are concerning the laws on illegal immigration or immigration or foreigners which are coming. So one is the Foreigners Act 1946 and second is the Passport Entry Act. Then I even told you this Foreigners Act 1946 is very draconian because onus of responsibility of proving that you are bona fide person and not an illegal person lies not on the state but on people itself. So now as far as this Foreigners Act 1946 is concerned, इसी एक्ट के अंदर foreigner tribunals are being constituted. ठीक है? So it is also a tribunal which is being constituted under this particular act. तो question ये पूछ रहा है that power to constitute foreign tribunal is vested only with district magistrate. Is this statement correct or not? So अब इसके बारे में थोड़ा सा समझ लो. What is this foreign tribunal? क्योंकि tribunals we are dealing. One, it is being created under Foreign Tribunal Act 1946. Two, this tribunal will be headed by a member who can be any retired judicial officer. He could be a bureaucrat. He could be a lawyer. ठीक है? Chairman कौन होगा? He could be a member, as in it is headed by a member who could be retired judicial officer. He could be a bureaucrat. He could be a lawyer. He should have minimum 7 years of legal practice. एक और requirement है. Ministry of Home Affairs is looking into this act. So it has made certain changes in this particular act as well. After this particular change happened from Ministry of Home Affairs in 1964, it was being said that district magistrates in states and UTs are empowered to set up these foreign tribunals. इसीलिए ये question आया है. ठीक है? So ministry had made through an order a change in 1964. So अभी रुको. So after this, district magistrates in all the states are therefore empowered to set up. It is them to decide, and it is the tribunal. पहले पूरा समझते हैं. It is the tribunal to decide whether a person who is staying in India is illegally a foreigner or not. And before, क्योंकि केस सीधे foreigner tribunal में आ जाएगा. ठीक है? Before the amendment, the power was there with the center. After this amendment, one individual can approach the tribunal while it was not the case earlier. So abhi individual can even go to the tribunal to figure out, right? Now central government or state government or UT or collector or district magistrate may refer the question as to whether a person is a foreigner or not to this particular foreign tribunal. and this needs to be taken forward by Foreigners Act 1946. Now coming to the question. So the question is saying the power to constitute is vested only with the district magistrate or not. So yes, abhi after the change has happened, now it is up to the district magistrate to refer this particular matter to the foreign tribunal. Second statement is that whether they are set under Citizenship Act 1955, so you would say no, they are not taken up. Foreign tribunal 1964 के change के बाद आया है, right? So it is not initially part of this Citizenship Act 1955. ठीक है? So अभी का statement, the thing is that yes, of course, this tribunal को the power to constitute this particular tribunal is being given to the district magistrate of every. पहले क्या था? Center को ये power दे दी गई थी. Now it is being given to the district magistrate. ठीक है? So this particular, this is the way I found it very interesting. So statement 1 would be true and statement 2 would be false, right? So any other issue? Dhananjay likh rahe hain, both are statutory. Yes, both are statutory in nature. Let me see if there is any other question, else we are winding its session. Now, एक question आ सकता है. This is regarding, because tribunal की बात हुई है, interstate river disputes are there, and in order to come out with interstate river disputes, there are water tribunals or interstate water tribunals which are also being set up. So in order to come out with interstate disputes, these disputes are basically regarding Krishna, Narmada, Mahanadi and Godavari. So of course a question can come up regarding the water dispute tribunals and their chronology. So somewhere you can write chronologically, first is Krishna Water Dispute Tribunal. This happened in 1969. I would be going slow, you can note it down, क्योंकि water becomes a very important category regarding tribunals. तो अगर हम water dispute tribunals देखें, which would come up in the other category apart from CAT and SAT. So 1969 में Krishna Water Dispute Tribunal was set up. Krishna Water Dispute Tribunal is between states of Maharashtra, Karnataka and Andhra Pradesh. ठीक है? कृष्णा डिस्प्यूट किसके बीच में है? महाराष्ट्र, कर्नाटक एंड आंध्र प्रदेश. हाँ, अभी तो अब तेलंगाना कैटेगरी हैज आल्सो कम अप. गोदावरी वाटर डिस्प्यूट ट्राइब्यूनल, Godavari Water Dispute Tribunal, this was also created in the same year 1969. Herein the aggrieved party or the conflicting party would be Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh and Odisha. Two more states are included apart from the above three states. This would be MP and Odisha. हाँ, अभी उसमें छत्तीसगढ़ का आइडिया, मतलब earlier it was 1969, no? So वो उस समय की स्टेट का है. अभी तो उसे nomenclature of course have changed. Next is again the same year, Narmada Water Dispute Tribunal came up. Narmada Water Dispute Tribunal में who are the conflicting states? Now Rajasthan is there, Gujarat is there, MP and Maharashtra is there. And then is Mahadai, Mahadai, Mahadai Water Dispute Tribunal. This is most recent, very recent, 2010. This has come up between Goa, Karnataka and Maharashtra. ठीक है? There are other water dispute tribunals also, like 2010. 2010 में एक और water dispute tribunal बना. This is called Vasandhara Water Dispute Tribunal. This is between Odisha and Andhra. Vasandhara. Kaveri Water Dispute, so we all know, year 1990, between Karnataka, Tamil Nadu, Kerala and Puducherry. Kaveri Water Dispute Tribunal, Karnataka, Tamil Nadu, Kerala and Puducherry. Since we are dealing with river water disputes, kindly write an article. This is article, कौन सा article है? 262. So article 262 of the constitution provides for abjudication of interstate water dispute. Article 262 provides adjudication of interstate water dispute, and the same article says that Parliament of India may provide for adjudication of such dispute, may provide laws, for adjudication of such dispute. These dispute could be in regard to use, distribution and control of water. Accordingly, as far as this article 262 is concerned, क्योंकि parliament को दी गई थी power to come out with dispute redressal, this is the reason two acts came up. One act was River Board Act 1956 and another was Interstate Water Dispute Act 1956. ठीक है? So article 262 के basis में parliament then passed two acts. One is River Board Act 1956, another is Interstate Water Dispute Act 1956. So we have dealt almost with all categories of tribunals as well, right? So this is all for today's discussion. Tomorrow would be our last topic. Tomorrow what all we are going to discuss, I'll tell you. First, we are going to start with election. Election में first we are going to discuss different ways of election. So this is first past the post system and proportional representation. Then we are going to discuss the role of election commission. Then we are going to figure out RPA 1950 and RPA 1951. What is the difference? What would be if there is election dispute? What are disqualification for grounds? And election related offenses. यानी पूरा election का idea we would be discussing, and after that we are going to discuss few important constitutional and statutory body. ठीक है? It would include UPSC, Finance Commission, CAT, Niti Aayog, NCSC, NCST, NCBC, NHRC and CIC. These would be few more bodies which we shall be discussing. तो कल हमारा idea election से शुरू होगा. It would be ending with constitutional and statutory body. Okay, thank you so much.